So the fabulous program that you are about to hear is brought to us by Professor Geoff Stone, who is a renowned First Amendment scholar. He holds the Edward H. Levi Distinguished Service Professor Chair at the University of Chicago. He joined the faculty in 1973 after serving as a law clerk for the Supreme Court Justice William J. Brennan, Jr. He also served as the dean of the law school and provost of the University of Chicago. Among his many other accomplishments was his tenure as part of the President Obama's commission to review, it was the President's Review Group on Intelligence and Communications Technologies, which evaluated the government's foreign intelligence surveillance programs in the wake of Edward Snowden's leaks. Mr. Stone is the author and co-author of numerous books on constitutional law. In his most recent book, Sex and the Constitution, explores the history of sex, religion, law, and constitutional law from the ancient world to the present. And a portion of the book is going to be a topic of his presentation today. Please welcome Geoff Stone.
Thank you, Svetlana. I'm delighted to be back. I've been here several times before, and I've always enjoyed it. And so I've always been eager to return. So as Svetlana said, my new book, Sex and the Constitution, explores the history of sex, religion, law, and constitutional law from the ancient world to the present. And my goal in writing it was to try to illuminate the process by which American law has called into question the constitutionality of a broad range of government regulations of sexually related behavior, including contraception, abortion, obscenity, sodomy, and marriage. In the course of this process, the Supreme Court has found itself confronting fundamental questions about the nature of sexual freedom, the meaning of liberty, equality, and privacy, the legitimacy of government efforts to dictate sexual morality, and the appropriate role of religion in public life. Now, to introduce Sex and the Constitution to you this morning, I want to tell you a story. It's a story about what, for 4 decades, has been one of the most bitterly divisive issues in American politics, the Supreme Court's 1973 decision in Roe v. Wade. Now, opponents of Roe maintained that the court invented a constitutional right out of whole cloth without any legitimate justification. Supporters of Roe maintained that it was a perfectly sound decision that correctly recognized a fundamental constitutional right. Now, whether one agrees or disagrees with Roe, contemporary understandings of the case and of its historical origins are often confused and incomplete. The story of how we got to Roe v. Wade, like the story of how we got to Brown versus Board of Education, or how we got to Obergefell versus Hodges, the same-sex marriage decision, is important to remember, for it gives both content and context to the debates of the present. So let us begin at the beginning. At the time our Constitution was drafted, abortion was often relied upon, particularly by single and widowed women, to avoid the consequences of illegitimate births. In that era, contrary to what many people today assume, abortion before quickening, that is, before the point at which the woman could feel movement, typically at around 4.5 months, was perfectly legal. Indeed, this had been the unbroken state of the law at least as far back as the ancient Greeks. Although the Church in the Middle Ages condemned abortion as a sin, the law did not treat it as a crime. To the contrary, those who did not share the faith were perfectly free in this regard to do as they wished. Abortion was also common and legal in England in the years leading up to the American Revolution. As Lady Caroline Fox wrote to her husband in the 1740s, upon learning that she was pregnant for the 3rd time in as many years, quote, "I'm certainly breeding. I shall take care of this promptly in the hopes of sending it away." Soon thereafter, she wrote her husband that she'd been successful, noting, "is not that clever." The American colonies embraced the same approach to abortion as the English common law, and abortion before quickening was both common and legal. Moreover, even abortion after quickening was never punished. Now, over the course of the 19th century, abortion became ever more common. This was evident in the fact that the birth rate in the United States fell dramatically from 1800 to 1900. In the colonial era, the average family had 9 children. By 1900, that number had declined to only 3. The reason for the change was clear. In the agrarian world of the 18th century, children were an important economic asset. But by the end of the 19th century, with greater urbanization, children were increasingly seen as a financial burden that could cause a family's economic ruin. Thus, for most families, birth control had now become essential, and because contraception was still generally unreliable, abortion was seen as a critical way of managing family size. Indeed, by the middle of the 19th century, approximately 20% of all pregnancies ended in abortion. At this time, daily newspapers regularly ran ads for abortifacients, and those who provided abortion services did so quite openly. The flamboyant Anne Lohman Restel of New York, for example, who was popularly known as Madame Restel, maintained a highly profitable abortion business, serving a genteel middle and upper class clientele. She touted her celebrated powers for married ladies, and like many of her competitors, she broadly advertised her services in the press of the day. To give you just a sense of the times, here's an example of one of her widely distributed advertisements. Quote, "To married women, is it but too well known that the families of the married often increase beyond what the happiness of those who give birth would dictate? In how many instances does the hard-working father, and more especially the mother, of a poor family remain slaves throughout their lives, urging at the oar of incessant labor, toiling to live, living but to toil? Is it desirable, then, for parents to increase their families, regardless of consequences to themselves or to the well-being of their offspring, when a simple, easy, healthy, and certain remedy is within our control?" Now, the general acceptance of abortion as an appropriate method of managing family size first began to change in the latter part of the 19th century. 2 factors in particular contributed to this shift. First, religious perspectives on abortion began to change during the evangelical explosion of the Second Great Awakening. The traditional Protestant conception of the fetus assumed that it was not alive until the point of quickening. But abandoning that view, evangelicals during the Second Great Awakening began for the first time to preach that a separate, distinct, and precious human life came into being at the very moment of conception. Second, medical professionals in this era increasingly came to the view, based partly on religion and partly on half-baked science, that human life begins at conception. A professor at the University of Pennsylvania Medical School, for example, published a pamphlet in which he confidently asserted that newly conceived embryos can think and can perceive right from wrong. And in the late 1850s, the Boston doctor and religious moralist Horatio Storer initiated a concerted physicians' crusade against abortion. Now, at this time, there was a growing sense that women were evil temptresses who were driven by Eve-like impulses that would lead them to corrupt and to betray their men. It was therefore necessary for the law to eliminate abortion in order to keep those women under control. Against this background, Storer decried the growing frequency of abortion and maintained that the primary cause of this phenomenon was the general demoralization of women. Storer insisted that some women who have an abortion die either immediately or shortly thereafter as a result of moral shock from the very thought of what they have done, while many others were driven to insanity. Storer charged that children born to a woman after she has had an abortion are often deformed or diseased, and that they too therefore bear the burden of their mother's heinous act. Storer emphatically rejected the notion that a woman should decide this question for herself, because he explained during pregnancy, quote, "A woman's mind is prone to derangement." As a result of Storer's campaign, in 1859, the newly founded American Medical Association adopted a resolution condemning abortion at every stage of gestation, except if a doctor finds it necessary to save the life of a woman. Over the next several decades, the AMA, working hand in hand with religious moralists during the late 19th century social purity movement, launched an aggressive and ultimately successful campaign to rid the nation not only of abortion, but of contraception as well. As the leading voices of this movement explained, the sole purpose of women is to produce children, and women must therefore remain within their God-given sphere. By the end of the 19th century, in a complete reversal of the world of the framers, every state had enacted legislation prohibiting the distribution of any product designed for the purpose of contraception, for any information about contraception, and every state had enacted legislation prohibiting abortion at any stage of pregnancy unless a doctor certified that the abortion was necessary to save the life of the woman. Thus, for the first time in Western history, abortion was unlawful even before quickening, and women who sought abortions were now themselves subject to prosecution. Opponents of birth control insisted that the issue was simple. If a woman didn't want to get pregnant, then she shouldn't do anything that might get her pregnant. It was as simple as that. But despite the threat of criminal sanctions, the medical profession's often perverse warnings about the dangers of abortion and the preaching of religious moralists, women in the late 19th century continued to seek abortion in record numbers. Indeed, by the turn of the 20th century, approximately 2 million women each year had illegal abortions, and almost a third of all pregnancies now ended in abortion. But now, for the first time in history, these abortions had to be performed illegally, in secret and in unsafe circumstances, and by much less reliable practitioners than in the past. By the 1960s, with improvements in contraception, which was now increasingly, but still not universally legal, the number of unwanted pregnancies gradually declined. But even then, approximately 1 million women each year resorted to illegal abortions. The vast majority of these women turned either to self-induced abortion or to the dark and often forbidding world of back alley abortions. Women who resorted to self-induced abortion typically relied on such methods as throwing themselves down a flight of stairs or ingesting or inserting into themselves a chilling variety of chemicals or toxins, ranging from bleach to turpentine to gunpowder. Knitting needles, crochet hooks, scissors, and coat hangers were among the tools most commonly used by women who attempted to self-abort. Approximately 30% of all illegal abortions at this time were self-induced. Women who sought abortions from back alley abortionists encountered similar horrors. To find someone to perform an illegal abortion, women often had to rely on tips from elevator operators, taxicab drivers, salesmen, and the like. Because of the clandestine nature of illegal abortions, the very process of finding an abortionist was dangerous and terrifying. Women who sought back alley abortions were often blindfolded, driven to remote areas, and passed off to people they did not know and could not even see during the entire process. Such abortions were performed not only in secret offices and hotel rooms, but also in dank bathrooms, in the back seats of cars, and literally in back alleys. The vast majority of these abortions were now performed either by persons with limited training or by rank amateurs, including elevator operators, prostitutes, barbers, and unskilled laborers. In the 1960s, an average of more than 200 women died each year as a result of botched illegal abortions. And in addition to those who died in the course of illegal abortions, many thousands more suffered serious illness or injury. And this world was one of secrecy and shame. Women who sought abortions in this world could not tell anyone what they had done, why they had done it, or what they had experienced, because to do so was criminal and, indeed, in the culture of the day, shameful. The stories of women who suffered through this nightmare that did come to light are horrendous. One woman recalled how a fellow college student who had had an illegal abortion was too frightened to tell anyone what she had done. She locked herself in the bathroom in her dorm and quietly bled to death. In another incident, 28-year-old Geraldine Santoro bled to death on the floor of a Connecticut hotel room after she and a former lover attempted an abortion on their own. The former lover, who had no medical experience, used a textbook and some borrowed tools. When things went terribly wrong, he fled the scene, and Santoro died alone. Now, the occasional visibility of such incidents, particularly when individuals died, led some religious organizations that had previously been silent on the issue of abortion to address the question more directly. Protestant churches varied in their opinions. The United Methodist Church, for example, acknowledged, quote, the sanctity of unborn human life, but nonetheless proclaimed that because we are equally bound to respect the sacredness of the life and well-being of the woman, for whom devastating damage may result from an unacceptable pregnancy, we support the removal of abortion from the criminal code. Similarly, in 1968, the American Baptist Convention came to the conclusion that abortion should be a matter of responsible personal decision. The Catholic Church, on the other hand, insisted that abortion was always and unequivocally forbidden, even when necessary to save the life of the woman. Now, this led the politics of abortion to play out in interesting ways. Because Catholics had traditionally identified with the Democratic Party, and because Catholics were more likely than others to oppose abortion, Republicans at this time were more pro-abortion than Democrats. Although we often forget this fact, it's interesting to recall that in early 1972, 59% of Democrats and 68% of Republicans thought that the decision to have an abortion should be made solely by a woman and a physician. Indeed, Republican politicians spearheaded some of the earliest efforts to liberalize abortion laws. Barry Goldwater, for example, one of the Republican Party's conservative icons, supported abortion rights. And in 1967, California Governor Ronald Reagan signed a bill liberalizing that state's abortion laws. But because of other, more liberal elements in the Democratic Party itself was officially more pro-abortion than the Republican Party. Seeing an opportunity to draw disaffected Catholics away from the Democrats, Republican leaders began to move towards a more anti-abortion stance. They knew that if they could succeed in this effort, they could bring about a profound shift in American politics. This strategy was clearly evident in President Richard Nixon's policies during the 1972 election. With a clear sense of the political ramifications of the abortion issue, Nixon embraced an anti-abortion stance in a strategic effort to draw Catholics into the Republican camp. Nixon knew what he was doing. In the 1972 election, large numbers of Catholics who were prepared to cast single-issue votes on the issue of abortion voted Republican for the first time in their lives, helping Nixon to win an overwhelming victory in that year's presidential election. At roughly the same time, though, the rising voice of the women's movement began to shape public discourse on abortion. In February of 1969, for example, Betty Friedan, the founding president of the National Organization for Women, delivered a rousing address in Chicago at what was billed as the first national conference on abortion laws. Friedan declared that, quote, "There is no freedom, no equality possible for women until we assert and demand the control over our own bodies, over our own reproductive process." At the end of this conference, the participants founded the National Association for Repeal of Abortion Laws, NARAL, on the premise that what was needed was a complete overhaul of America's abortion laws. Later that year, Planned Parenthood and the American Public Health Association also called for repeal of America's abortion laws and declared abortion to be a fundamental personal right of women. As these organizations moved to the forefront of national debate, and as women now began to speak out publicly about their experiences in the world of abortion, the law began to change. In 1970, 4 states, Hawaii, Alaska, Washington, and New York, legalized abortion in the first trimester, thus restoring the law to more or less what it had been at the time that our Constitution was adopted. Opponents of these laws quickly mobilized their forces, however, and adding fuel to the fire, in early 1972, Congress approved the Equal Rights Amendment and submitted it to the states for ratification. This immediately led religious and conservative activists to tie the issue of abortion to even larger concerns about the appropriate role of women in American society and to the meaning of so-called family values. Suddenly, the legislative progress on abortion that had begun only a few years earlier ground to a halt. Despite growing and clear majority support for legalizing abortion, no state legislature now acted on that issue. Single-issue voters basically controlled the process. Indeed, in New York State, which had legalized its abortion law in 1969, a year later, the legislature, acting now under fear of not being reelected, repealed their repeal and reestablished the old late 19th century law. Republican Governor Nelson Rockefeller vetoed that repeal of the modern law, saying that the clear majority of citizens of our state support the right of women to make decisions for themselves about abortion. The only reason the legislature has acted the way it did was because of religious concerns and in a society dedicated to the separation of church and state that is not a legitimate basis for denying women the freedom to decide for themselves. But faced with the sudden paralysis in the legislative arena, pro-choice advocates began for the first time to think about challenging the constitutionality of anti-abortion laws in the courts. Now, initially, this seemed a long shot, because in the words of New York Times columnist Linda Greenhouse, the idea of a constitutional right of abortion seemed somewhat illusory. But with legislative change effectively blocked across the nation, the courts now seem the only realistic alternative. In 1970, the Connecticut legislature repeatedly refused to amend its 19th century anti-abortion statute, and a group of women activists formed a new organization, Women Against Connecticut, to challenge the constitutionality of the law. We want control of our own bodies, they declared. We are tired of being pressured to have children or not to have children. It is our decision. 6 weeks after Women versus Connecticut filed its complaint in federal court on behalf of 858 women plaintiffs, the federal court held that the Connecticut law was unconstitutional. Judge Edward Lombard, a conservative Eisenhower appointee, held that in this law, quote, Connecticut trespasses unjustifiably on the personal privacy and liberty of its female citizens in violation of the United States Constitution, and that the state's purported interest in banning abortion are insufficient to take from the woman the decision that she, as the appropriate decision maker, must be free to choose. In Georgia, another case arose as anti-abortion laws now started being challenged across the nation. In Georgia, a group of plaintiffs, including doctors and members of the clergy, challenged the constitutionality of Georgia's anti-abortion statute. And the federal court in Georgia also held the law unconstitutional, explaining that the constitutional concept of personal liberty embodies a right to privacy that is broad enough to include the decision to terminate an unwanted pregnancy. At roughly the same time in Texas, Linda Coffey and Sarah Weddington, recent graduates of the University of Texas Law School, teamed up with a plaintiff identified only as Jane Roe to protect her anonymity, to challenge the Texas anti-abortion statute. On June 17, 1970, the federal court in Texas held that the law violated the fundamental right of women to decide for themselves whether or not to have children. A year later, the Supreme Court of the United States announced that it would hear the case of Roe versus Wade. Now, many Americans today think of Roe v. Wade as a radical left-wing decision, but that was not at all the view at the time. By 1973, a substantial majority of Americans supported the right of a woman to terminate an unwanted pregnancy. And Gallup polls showed that 2 out of 3 Americans think abortion should be a matter for decision solely between a woman and her physician. Moreover, as we've seen, the lower courts were already moving sharply in a direction that anticipated the decision in Roe. In an overwhelming 7-2 decision, the Supreme Court held that these lower courts were correct and that the Constitution does indeed guarantee a woman's right to decide for herself whether or not to bear a child. Strikingly, 3 of the 4 justices appointed to the court by Richard Nixon, who had dedicated himself to appointing conservative justices, joined this decision. Indeed, without their support, Roe would have come out the other way. That Warren Burger, Harry Blackmun, and Lewis Powell joined Justices Douglas, Brennan, Stewart, and Marshall in Roe speaks volumes about the mainstream nature of the decision at the time. The plain and simple fact is that at the time Roe v. Wade was decided, the justices did not view the abortion issue as posing a particularly divisive ideological question. Although the justices certainly understood the stakes in the case, none of them imagined that Roe would later come to be a central flashpoint of American politics. This understanding of Roe is consistent with both the news coverage and the public reaction at the time. Because Lyndon Johnson died on the same day that the court announced its decision in Roe, newspapers, magazines, and news stories treated Roe as only a secondary headline. U.S. News & World Report, for example, did not even mention Roe on the front page of that week's issue. As the editors observed 40 years later, the far-reaching effects of the decision simply weren't evident at the time. This view is also consistent with the editorials and commentary about Roe, which were overwhelmingly approving. Even newspapers in traditionally conservative states took this view. The Atlanta Constitution, for example, characterized the decision as, quote, realistic and appropriate. The Houston Chronicle called it sound. And the San Antonio Light gushed that although the ruling was not perfect, it was as close to it as humanly possible. Moreover, the American people clearly endorsed the decision. In polls taken at the time, only 40% of Americans disapproved of the court's decision in Roe. To put that in perspective, it's useful to compare the public's reaction to Roe with its reaction to other, more controversial decisions. In 1962, for example, after the Supreme Court held prayer in public schools unconstitutional, 79% of Americans disapproved of the decision. In 1967, after the court held laws prohibiting interracial marriage unconstitutional, 72% disapproved. In 2010, after the court held laws limiting corporate campaign expenditures unconstitutional, 80% of Americans disapproved, but only 40% of Americans disagreed with Roe. An additional measure of just how uncontroversial Roe was at the time is the fact that when President Gerald Ford nominated John Paul Stevens to succeed Justice William O. Douglas on the court in 1975, not a single senator asked Stevens a question about Roe or about his views on abortion. It simply wasn't interesting. Even most evangelicals did not challenge the decision, for in 1973, most evangelicals still regarded abortion as a Catholic issue. The one group that did strongly condemn Roe from the very moment of the decision were Catholics, who disapproved of the decision by a margin of 56 to 40%. Indeed, within days of the decision, thousands of telegrams and letters of protest from Catholics began pouring into the court. Many of them form letters from Catholic school students denouncing the justices as murderers and butchers. The vast majority of these letters and telegrams were addressed either to Justice Blackmun, the author of the court's opinion, or to Justice Brennan, the court's only Catholic justice, for whom I was serving as a law clerk at the time. And in light of that, I'll tell you an interesting story about what it was like inside the world of the Supreme Court at this time. So the court was inundated with these letters and telegrams. Most of the justices, including Brennan, decided it was inappropriate for them to read them, but they piled up in boxes in the corridors of the Supreme Court. And this was something that had basically never happened before, so no one knew what to do about it. The court didn't have a staff that was capable of dealing with all these boxes. So the only people who actually wound up going through the boxes and going through the mail, typically at 2 o'clock in the morning, were the law clerks, many of whom had flown around the country interviewing for jobs with law firms, and they were waiting for their reimbursement checks. And so there they were at 2 in the morning cursing, going through letter after letter after letter, looking for the damn check. From some firm in Phoenix or whatever. The other story I'll share with you is a sort of personal one. When all of these letters were inundating the court, late at night, maybe 1 o'clock in the morning, I walked over to Justice Blackmun's chambers to see if one of his clerks was still there, because I was working on a case with him. And when I got to Blackmun's chambers, the door to the chambers were open. Most of the lights were out, but I could see that Blackmun was sitting at his desk with his feet up on the desk and a big pile of these letters next to him. And his glasses were down around his nose like this, and he was reading these letters. And years later, I remember reflecting on that moment, because thereafter, Blackmun increasingly became a justice who was more empathetic to parties in the Supreme Court in cases involving criminal justice and civil rights and individual freedoms. And it occurred to me, I may just have imagined this, that it may have been that experience of reading these letters, one after another, were calling him horrible names, that maybe gave Blackmun the insight of what it was like in the United States to be somebody who was viewed as someone who was completely dissed and unvalued and hated by others. And that may have changed his understanding of his role as a Supreme Court justice. In any event, as we know, Roe eventually emerged into a bitterly divisive issue. But this did not happen until the end of the decade, as the culture wars exploded over such issues as the Equal Rights Amendment, gay rights, obscenity, and women's liberation, thus inflaming the evangelical community. By this time, polls showed that more than a third of all Americans identified themselves as born again, and evangelicals have become the nation's largest religious demographic. When Reverend Jerry Falwell founded the Moral Majority in 1979, he brought together for the first time the many disparate elements of Christian fundamentalism into a single, unified political movement. Falwell explained that if evangelicals worked together, they had the power to take control of the national government. the moral majority raised huge amounts of money to support political candidates, and in state after state, its members wrested control of the state Republican apparatus from party regulars. By the summer of 1980, Republican Party leaders were treating Falwell more than any other religious figure in American history, like the leader of a powerful political constituency. The Christian broadcaster Pat Robertson boasted that the evangelical community now had enough votes to run the country. And in his pursuit of the presidency, Ronald Reagan now called for a constitutional amendment to overturn Roe v. Wade and promised to appoint pro-life judges at all levels of the federal judiciary, thus ushering in a historic era of judicial nominations shaped in no small part by religious conceptions of constitutional law. With Reagan's election, James Dobson, the founder of Focus on the Family, proclaimed that evangelicals had finally come home, and that home was the White House. In the years since 1980, a succession of Republican presidents have sought to appoint Supreme Court justices who would overturn Roe v. Wade. Interestingly, though, 3 of those justices, Sandra Day O'Connor, Anthony Kennedy, and David Souter, disappointed those who appointed them, demonstrating a respect for precedent, an understanding of the plight of women in a world in which abortion is illegal, and an appreciation of the fundamental right that was at issue in Roe. O'Connor, Kennedy, and Souter consistently reaffirmed Roe v. Wade, despite repeated efforts to overturn the decision. Having learned this lesson, though, Republican presidents have grown ever more determined not to replicate the mistake. And with the appointment of justices like Antonin Scalia, Clarence Thomas, John Roberts, and Samuel Alito, the court has come several times within a hair's breadth of eviscerating Roe. So where are we today? Well, had President Obama's nominee, Chief Judge Merrick Garland, been confirmed by the Senate, as he should have been, that would have pretty much locked Roe into place for the foreseeable future, for there then would have been 6 justices on the court who supported a woman's right to decide for herself whether to bear a child. But largely to prevent this outcome, Senate Republicans, in an unconscionable abuse of authority, refused even to consider Merrick Garland's nomination in the hope that an anti-abortion Republican would win the White House in 2016. Now, with the confirmation of Justice Neil Gorsuch, this puts the court back where it was before Justice Scalia's death. That is, the court now still will reaffirm in a 5-4 vote Roe versus Wade. But if one of the 3 oldest justices, Ruth Bader Ginsburg, Anthony Kennedy, or Stephen Breyer, should leave the court in the next few years for reasons of health or otherwise, and if Donald Trump gets to appoint another committed conservative to the court, there will then be 5 justices on the Supreme Court who will likely vote to overrule Roe versus Wade. In the United States today, 30% of all women have at least one abortion during their lives, and approximately 1 million legal abortions are performed in the United States annually. If Roe is overruled, some states will no doubt legalize abortion, but most will not. Think of the Electoral College. If this comes to pass, then hundreds of thousands of women, mostly poor and minority, will once again be thrown each year into the dark and dangerous world of back alley abortions. So what then is the takeaway of this talk? Well, the main point is to make clear that a world where abortion is illegal is not the state of nature. From the ancient world until the late 19th century, abortion was readily and legally available to women throughout history. Roe did not mark a radical departure, but a return to the world of the framers. It was only the illegitimate infusion of religious dogma into our secular law that changed all this. And especially in a nation dedicated to the separation of church and state, this is truly a tragedy waiting once again to happen. Thank you. I'll just sit here.
Thank you. I actually have 2 questions. Is that fair? No. All right. So I have actually 2 important questions, but I will ask one important question is how much do you think that the immediate funding by the Catholic bishops of the right to life and the groups that the Protestant groups that were essentially fronts for the Catholic bishops. And the millions of dollars that was poured into that led to the very politicization, I can't say that word this early, of the Protestants, who were really not all that much anti-abortion to begin with, because as you said, they thought it was a Catholic problem. So how much do you think that led to their politicization? And how big of a factor was that, the Catholic funding of these original Operation Rescue, or what developed into Operational Rescue groups?
I would say that the Catholic funding had an impact, but I think that what really drove the evolution of the Protestant views on this was not so much the views about abortion, but the fact that they decided that they needed to be imposed on other people. So that is, I think the evangelicals before 1979 basically took the view that they were opposed to abortion themselves, that they wouldn't have abortions, they would be unhappy if a family member had an abortion, but they didn't see it as a political issue that they wanted to get involved in. I think the real driving force there was the sense that there was an attack on traditional cultural values that went beyond abortion to the various issues I raised before, the beginning of the gay rights movement, the effects of the women's rights movement, the Equal Rights Amendment. You know, when the Equal Rights Amendment passed Congress, it was overwhelmingly supported by both Republicans and Democrats. Everybody thought it would be ratified shortly without any difficulty, and it never got ratified. And so what happened was, I think, a combination of things came together and energized the evangelical community, which made them start seeing that they wanted to control and needed to control the political process, because all of these issues were at stake. And what they saw is the values of the nation were now at stake because they were being eroded. So it was not only the abortion issue, I think, that drove it. Now, Catholic funding, I think, helped that. It supported that direction. But I really think it was the sense of outrage about this is no longer our country. And people are trying to destroy the moral fabric of our country, and we now need to step up and be much more aggressive than we were before. I think that was the pivotal thing that led to the moral majority.
How do originalists argue against a constitutional right to abortion, considering the fact that abortion before quickening was legal at the founding of our country?
So originalists would argue simply that the only things that should be held unconstitutional under our Constitution are those laws that the framers themselves affirmatively understood would be prohibited by the Constitution. And on the question of abortion, nobody ever talked about the question. So one can't actually say that the framers had any particular view on whether there should be a constitutional right of abortion. There are lots of things that are legal today, eating meat, for example, right, that we don't think about as a constitutional right to eat meat, right? But someday down the future, one could imagine a world in which, you know, there's a movement to ban eating meat, and people say I have a constitutional right to do it. Everybody was allowed to do it when the Constitution was adopted. So I think they would argue that, yes, it was legal, but they would say nobody was even thinking about whether it should be a constitutional right, and therefore there's no identifiable understanding of the original Constitution that would have held it to be a constitutional right. That's how they would answer that question. And again, from a strict originalist perspective, that's a persuasive answer. Although originalism is bullshit, but that's a different question.
Thank you, Professor. I'm thinking, you make me think about Miranda versus the state of Arizona and criminal procedure, and how that once exotic principle got integrated into our society and no longer is really all that controversial. I'm hoping my assumption is correct. In the same vein, you as a law clerk and seeing the dynamics on the Supreme Court, and knowing that Roe v. Wade has been reaffirmed over and over and over again by that same tribunal, can you comment on your impression of how the difficulty of any group of majority on the Supreme Court to actually upset stare decisis. Can you give us your impression on that?
Sure.
Is it going to be easy, or, I mean, it won't be easy, but let's hear what you have to say.
So, first of all, on Miranda v. Arizona, Miranda, of course, is the case where the Warren Court held that when an individual is taken into custody and questioned, they have to be warned of their right to remain silent, the right to counsel, and so on. Very controversial decision. It was strongly opposed by conservatives at the time as hamstringing the police, making it more difficult to enforce the law. When the Burger Court came into being with Richard Nixon's 4 nominees, and one of the campaign pledges that Nixon made was to get rid of the Warren Court and create what was regarded by them as a more restrained Supreme Court. Miranda was one of the cases that was often trotted out as one of the, it was perceived as an abuse of the judicial power. And so people thought that the court might overrule Miranda. It did not. Part of the reason it did not is because it became accepted within the police society and community as not as damaging as people might have thought, and as actually in many ways positive. So the objections to Miranda softened by the time we got to the 1970s. And so the court cut back on it. It restricted it in a range of different ways. But to the surprise of many people, it didn't overrule Miranda. And Miranda remains largely intact for today. So with Roe, I think there are a couple of differences. The first is that the objection to Roe has continued to be as strong as it ever has been, and has not changed, unlike the situation with Miranda. But the question is, when should a court overrule a prior decision? So the doctrine of precedent is an important one in the legal system because you want citizens to know what the law is. And you don't want to live in a world in which you could be doing something one day and it's legal, and then the next day it's not legal because the court changed its mind. So both for that reason and to keep generally a sense of stability in the legal system, courts have followed a basic doctrine of a precedent. But the law of precedent is not absolute. There are situations where courts overrule prior decisions. The Supreme Court, for example, in Brown versus Board of Education, overruled Plessy versus Ferguson and held that separate but equal was unconstitutional. More recently in Citizens United, the Supreme Court overturned a 7-year-old decision on the issue of campaign finance. 7 years before Citizens United, the Supreme Court, in a 5-4 decision, upheld the constitutionality of the McCain-Feingold statute, which regulated campaign contributions by corporations. It was a bipartisan statute. It had been sponsored by John McCain, a Republican, and Russ Feingold, a Democrat, and signed into law by George W. Bush. Nonetheless, 4 conservative justices, when they first heard the case, argued it was unconstitutional, violating the First Amendment, but a majority of justices voted to uphold it. 7 years later, when Samuel Alito had replaced Sandra Day O'Connor, O'Connor had been in the majority in the earlier case, the McConnell case, the court overruled the case, simply because Alito had replaced O'Connor and gave no deference to the principle of stare decisis. So whether a court will follow the principle of precedent depends partly on whether the precedent has been eroded over the years, partly over how strongly they believe the initial decision was wrong. And in the Citizens United context, the 5 justices in the majority in that case strongly believed their earlier decision was wrong, even though it was only 7 years earlier. Nothing had changed. And they showed, in that context, no respect for the doctrine of precedent. And my guess is on the issue of abortion, the 5 conservative justices, if one of the 3 I mentioned is replaced by another Gorsuch, my guess is that they will vote to overrule Roe. Partly I say that because the current members of that group, Roberts, Alito, and Thomas, have consistently voted to overrule Roe v. Wade in cases that have arisen where challenges to various regulations of Roe have come before the court. They've made quite clear they regard Roe as the same way that the Warren Court regarded Plessy and Ferguson. is a completely illegitimate decision that has no business being part of the Constitution. And I have no doubt Judge Gorsuch takes that view. And so the two answers is, one is that the reason for opposing Roe remains as strong as it's ever been by people who believe abortion is murder. The justices on the court in this particular group have demonstrated in Citizens United and other cases I won't bother mentioning that they don't really have a strong respect for precedent when they feel strongly about the wrongness of the prior decision. And they've, in their dissenting opinions in a series of cases, made clear that they think Roe v. Wade should be overruled, that it was an illegitimate decision. So I would be very surprised they didn't vote to overrule Roe.
Thank you very much. It's fascinating for most of us, I'm sure. In your research on this, it focused mostly on the culture of this country, of this nation. But I was wondering if you, in your research, you also looked at cultures outside the United States, particularly, let's say, in Africa or in Asia, how they approach these basic concerns.
Right. I didn't look at that in any systematic way. I did casually look at it, and they're all over the lot, is what it turns out. But I didn't really look at it systematically. There's certainly been a movement around the world, particularly in Western democracies, to liberalize the laws about abortion. But many Western democracies still haven't gone as far as we have in this regard. Similar to, say, same-sex marriage, where most Western democracies still haven't gone as far as we have. And part of the reason for that is that we have a judicial system that regards the power and responsibility of courts to protect what are seen as fundamental human rights, whereas in most other countries, courts don't quite have that degree of authority. And so it winds up in the democratic process, which tends to be more hesitant about these things.
Hi. I'm wondering if you were surprised when Roberts voted to uphold the ACA through kind of a strange thing, and whether or not on the list that Trump is presumably going to pick from again, there might be anybody like that who isn't lock solid against Roe and would find a way to try to avoid the chaos that would follow.
So Chief Justice Roberts voted in the Affordable Care Act case, the Obamacare case, to uphold the ACA at a time when many people predicted it would be overruled. So in a 5-4 decision, they upheld it with Roberts in the majority. But I think people have blown that one vote way out of proportion. If you look at the 20 decisions that Roberts has participated in, where there are strong ideological stakes, in every one of those but that one case, he has voted with Thomas and Scalia and Alito. And particularly on every single case involving abortion, on every single case involving gay rights, he has emphatically written very strong opinions that show no ability or willingness or inclination to compromise. So I think Roberts has, although he got himself in trouble with some conservatives because of his vote in the Affordable Care Act case, I think he's won a lot of completely unjustified credibility with many other people. Because it remains the single instance since he's been on the Supreme Court where he voted in a case where one would strongly have predicted that he'd vote the other way. And this includes issues on voting rights, it includes issues on gerrymandering, it just crossed the spectrum, campaign finance, criminal procedure. So I think that was a one-off. And I think he did it for legitimate legal reasons. I mean, people think he did it for tactical, strategic reasons. I think Roberts actually thought, I don't think he cared that much about the issue. It wasn't a moral issue. And I think he basically approached it like a lawyer in a fairly neutral way in that respect, without strong priors. And even so, he wrote a pretty weird opinion, but he did vote to uphold the statute. So I wouldn't take all that much solace from that.
You referred to the intensity of opposition to abortion rights has not diminished, maybe even has increased in the years since the decision. This is very peculiar. Perhaps perhaps I have heard, perhaps, that part of the opposition has been a result of a political miscalculation by those who were for abortion rights, that they won such a sweeping victory that they helped to they helped to provoke opposition to Roe v. Wade, which if they had perhaps undertaken a more gradual approach, might not have fed that movement. Would you comment on that?
So Ruth Bader Ginsburg is one of the most visible proponents of this view. That is, Ginsburg has said that the court in Roe went too far, too fast. It should have taken its time and allowed the legislative process in the states to continue to evolve, and did this in a case-by-case basis in a very modest way. And so to take 10 or 15 or 20 years, if necessary, to get to the point of Roe, if it couldn't be a battle won in the legislature. So there are several, I think, complete misunderstandings on her part on this issue. One of them is the, I think, naive view that the legislative process would have changed in a significant way. The fact is that the opposition to Roe, even by the time Roe had come about, had become strong enough to prevent every state legislature to stop, including New York reversing itself on the issue of Roe. So I think that misunderstands how strong the opposition was going to be once it got focused. But the more important point, I think, is that what happened in Roe v. Wade was interesting. The court first heard argument in the case in the 1971-72 term of the Supreme Court. And during that term, there were only 7 justices. Rehnquist and Powell had not yet been confirmed when the court first heard oral argument in Roe v. Wade. And so Chief Justice Berger assigned the opinion to Harry Blackmun, and his goal was to write a very narrow decision. So what he wanted to do in the 1971-72 term was to write an opinion that invalidated the Texas statute on the ground of vagueness. That is, the rationale that they were going to decide the case on was that the Texas statute said that a doctor who performs an abortion is committing a criminal offense unless the abortion was necessary to save the life of the woman. And the argument was that, what do we mean by necessary? How is a doctor to know whether it was necessary? That's a vague concept. And should we put doctors in the position where they run the risk of committing a criminal offense when they can't really know for sure what necessary means? So this would have been an extremely narrow decision. It would have struck down the Texas statute on this technical basis, and it would have required states to enact legislation that clarified what they meant by necessary. But it would have left abortion illegal across the nation. And that was the intention that Blackmun decided to write on. Now, Justices Brennan, Douglas, Marshall were appalled by this, the more liberal justices, but that was the way Blackmun was going to write the opinion. By the end of the 71-72 term, he was still not satisfied that he had gotten it right. And because Powell and Rehnquist were now on the court, but couldn't participate in Roe because it had been argued before they were confirmed to the court decided to re-argue the case the following term, 72-73 term, when I was there as a law clerk then. And then Powell and Rehnquist could participate as justices, then it'd be a 9-justice court. So that summer, Justice Blackmun spent at the Mayo Clinic in Minnesota, where he had been a general counsel for a while and then on the Board of Trustees, and did research on abortion. And he came back with the stories that he learned at the Mayo Clinic about what the world had been like for women in a context in which abortion was illegal. And when the justices reheard argument in the 72-73 term, this was a powerful part of what they now had come to understand much more fully than they had earlier. And there was no way the justices in the majority, including even Berger, were going to adopt a very narrow approach and allow this to play itself out over a 10 or 15-year period, because they now understood what the world was like for women who were forced into illegal abortions. And having decided themselves that there is a constitutional right to abortion, they were not going to play a strategic game which will require women for the next 5, 10, 15 years to continue to live in that world of illegal abortions, just so it would be strategic to do that. And so that, I think, was the key factor that led them to say, that's not a strategy we can follow. Now that we've come to the view that this is a violation of the Constitution, and now that we understand what the consequences would be of an incremental, long-term, gradual approach, that's not plausible for us. That would be immoral. And I think that's what drove the justices to decide in Roe that they were going to take on the whole thing at one time. And I think it was the right decision at the time, and I don't believe that the world would have been different otherwise.
Thank you. We look forward every year to your talks. You're just wonderful. So my liberal friends, which actually says all my friends, when Garland wasn't approved by the Senate, really some of my friends said, why didn't Obama do something? If the Senate didn't act, maybe he could have appointed Garland on the court and see what the hell happened. And I'm just curious what you think about that.
Well, he couldn't have appointed Garland to the court because you need confirmation. He could have, in theory, made a recess appointment. So presidents are allowed to appoint judges or justices if the Congress is not in session, and they can then serve on the court until the Congress comes back into session. Well, since the Republicans controlled the Senate, they would have simply not gone out of session, and there would have been no recess. And they made that very clear. So that was simply not available. So I think Obama found himself in a position where there was really nothing he could do. Now, what he could have done was to make much more of a political and public issue about what the Republicans were doing. And the Democrats in the Senate could have made much more of an issue about it than they did. And to try to really use this as a weapon to get people to come out in the election. But I think part of the problem was they all assumed they were going to win the election. And they simply didn't do what they, with hindsight, should have done to win the election more generally. But this could have been used as a tool. But it also is a tool that could have backfired. Because, again, the issue of abortion is so inflammatory that if you make clear to the anti-abortion people that this is the stake, that the future of Roe v. Wade is at stake here, then it's a two-edged sword, right? Now, the reality, I think, is that the Republicans did a much better job of using abortion than the Democrats did in the 2016 election. And one of the things I think that the pro-choice people have failed to do, and I've said this to a number of them in Planned Parenthood events and so on, is they have failed to bring back vividly what the world is like when abortion is illegal. I mean, people who support abortion tend to think of it, oh, it's a right, they should be allowed to do it, right? Without really understanding what happens if it's not a right. And that's something that I think that the pro-choice people should be very aggressively and vividly portraying by telling people stories, by making a Netflix series about it, and making really vivid that this is the world we're talking about. It's not just an abstract legal issue of abortion or not. A world of non-abortion is not just you can't have an abortion. It's a world that is horrible and dangerous and frightening, and it's something we should not be willing to go back to. And I do think that the pro-choice side has failed to take advantage of that in the current moment.
And I'm just going to follow up with my prerogative here as a moderator. And along those lines, what about having like a coming out campaign of women from all walks of life coming out and saying, I had an abortion, these were my reasons, or these were whatever. I mean, you said 1 million women a year have abortion. I'm sure many of them are, extremely telegenic and articulate, and people, sort of along the lines of normalizing it and showing everyone that, it is your neighbor, it is your sister, it is your whoever. I mean, has that been considered as a tactic?
That's basically what I got to remember, they're all old now.
No, I'm talking about women now who have abortions, who avail themselves of abortions.
That's actually happened. There's a campaign called Shout Your Abortion.
Right.
Okay.
Shout Your Abortion is women doing this.
Right, just to show how actually frequently and safely it happens, and that understand, well, anyway.
Yes, I mean, I do think that would be a useful thing to do. But I think even more powerful is reminding people what the world is like if you go back to the illegality of abortion. But yeah, I mean, certainly women telling their stories about, and even today, women who have abortions tend to be very reluctant to be public about it. And that makes it more difficult to have an effective political movement for exactly the reasons you're suggesting.
What about the need for zero population growth for our planet to survive environmentally? Do you think that at some point that will be part of this discussion, or never?
Well, that was originally, interestingly, an important part of the movement of the early 20th century for not euthanasia, for, what do you call it, what's the word I'm forgetting, for eugenics, thank you, right, for eugenics. I think if people were to believe that there is a need for zero population growth both in our nation and around the world, and to come to the view that was important, that would have effects. The most obvious and dramatic one, of course, would be the availability of contraception. An interesting statistic is that right now there's roughly 1 million women a year have abortions, right? If you look at the percentage of women who have abortions, who have unwanted pregnancies, who are using contraception in an appropriate manner, it's close to infinitesimal. Almost all abortions today are by women who aren't using contraception appropriately, and in many cases it's because they can't afford it or don't have access to it. And if you really wanted to reduce the rate of abortions, if you made contraception readily available, freely available to poor people, with training about how to do this, the abortion rate would drop from roughly 1 million a year to 65,000 a year. If you simply take the percentage of unwanted pregnancies from people who use contraception versus the percentage of people who have unwanted pregnancies and therefore abortions who don't use contraception. And yet the people who are opposed to abortion are also opposed to contraception. And so there's this crazy, reality in which you could solve literally over 90% of the problem, to the extent it's a problem, by simply making contraception readily and freely available. Instead, what you have is the government in most states prohibiting it and not providing it for people who need it.
States like Texas are making it more difficult for women to have a safe abortion. Are other states doing that, and would you comment on that trend?
Yeah, some 28 states have passed laws that are designed to make abortion much more expensive and much more difficult. These examples of these are states that pass laws that require any facility that performs abortions to be the equivalent of a surgical center. So they have to have all of this equipment and staff that is completely unnecessary for abortion, as if they were performing heart surgery. And this raises the cost enormously. Or they have to be within a certain distance of a hospital. So that means all of the abortion clinics that exist that aren't now within that distance have to be put out of business. Or the doctors who perform abortions in these clinics have to have admitting privileges in hospitals nearby, but the hospitals will not allow you to be an admitting physician if you perform abortions. And these are all designed to basically drive abortion out of the state without literally making it illegal. Now, the Supreme Court 2 years ago held that those laws were unconstitutional in a 5-4 decision, with Justice Kennedy writing the majority opinion. And they held basically that these laws were clearly designed to prevent abortion rather than to serve legitimate interests about medical care, and that they had an undue burden on the right of women to exercise the freedom of choice. But nonetheless, states are continuing to put them in effect, continuing to enforce them, requiring then litigation by the abortion clinics to get the laws declared unconstitutional. So even though the Supreme Court has made clear that these policies are a violation of the Constitution, states continue to enact them, continue illegally to try to enforce them and to harass the abortion providers. And they come up with new, clever ways of doing this that weren't directly covered by the court's decision. So this is an ongoing battle. But the key thing is the court, I mean, a lot of people thought the court might go the other way on this case. And Justice Kennedy was the key swing vote, and he joined the majority to take a pretty strong position in saying all of these are basically disingenuous and they pose an undue burden on the right of the women.
You mentioned that the history of abortion law is really linked to the views of religious organizations, specifically the Catholic Church. And what I think is really interesting is that Catholicism also opposes contraception in general. And so why do you think politically and legally there's been more ability to block abortions than there has been to block contraception by these people?
Well, for one thing, the Supreme Court held that laws against contraception are unconstitutional. First in 1965 for married couples, and then in 1970 for anybody. And second of all, I think the evangelicals don't share this view. And so the Catholics alone, except in a few states, don't have enough power to do this. And I think they've also set their priorities. That, you know, they would probably, they is complicated, but the church officially would like to live in a world in which contraception was illegal. But I think the reality is a substantial percentage of Catholics don't share that view. And so you can't really motivate them to take that position. And I think abortion is the issue they're focused on as the much more fundamental one, partly because they know they can win on that one.
Sure. It's interesting that you referred to Justice Ginsburg. After Obama's re-election, I thought, you know, given her health compromises, that she should have retired. In 2015, two women wrote a book, a fawning book. It's called Notorious RBG. And in that book, they asked Justice Ginsburg when she was going to retire, and she says, after the election of Hillary Rodham Clinton. So my question is, at the federal level, how many appellate courts currently have an abortion case on their docket?
I don't know the answer to that question. I think given the current makeup of the court, there'd be no particular reason to bring an abortion case to the Supreme Court if you're from the conservative side, because there is a 5-4 majority that Kennedy just reaffirmed his view on that, and you're just going to lose. But I think that, you know, once there is a change in the court, if there is one, then I think we will see cases brought to the court very quickly. And it doesn't take that long to get up to the Supreme Court. So, but at the moment, I'm not aware of any major abortion cases in the lower courts. I'm sure there are some, particularly challenging some of these laws that I've talked about. But in those cases, the lower federal courts are going to invalidate the laws in light of the Supreme Court opinion. So I think basically, strategically, you're waiting for the change in the makeup of the court.
Hi, thanks so much for your talk. Might be a little bit of a loaded question, but when you're talking about when the first popularizing the making abortion illegal, when the state of quickening was considered the standard with the religious arguments, to me, there seemed to be a bit of a tinge of, you know, the argument was basically against giving the woman personhood. Is that something in your research that you saw like a lot of, even if it's just like undercurrents or insinuation of such when these laws are being proposed, whether in the past or currently?
Well, certainly the discourse about the issue had a lot to do with a woman's place. And so I think in terms of the Second Great Awakening, I think that was initially a little bit less about women as such than it was about the notion of being reborn. That is, what Protestants came to accept during the Second Great Awakening was the notion that you could be reborn in an instant, that you had this moment, right? And the idea that you could be reborn in an instant led the reconsideration to the notion of when you become a human. And is it the moment when you first are able to detect the motion, or is it at the moment of being literally created? So I think that was more of the driving force. But the notion of women being put in their place, as I said, also was a large theme in all this. the idea that women were feared because that there was a strong Eve-like sense that women are inherently temptresses. And there were these two competing views of women. There was the Mary-like view of women as pure and simple and honorable, and then there was the Eve-like view of women. And they've throughout history they've combated with one another. But the Eve-like one reemerged again with real power in the 19th century. And largely because of the Second Great Awakening, and then because of Anthony Comstock and the anti-pornography movement that emerged at that time. And women came to be seen then as kind of out of control and dangerous and needed to be brought back within control.